evidence that this public participation did not take place. It is my finding, therefore, that there was public participation at the county level and at the House of Parliament. The final step in assessing public participation under Article 257 is at the referendum stage, but we had not reached there. Lastly, on this question of public participation, I believe it is time for the legislature to urgently provide for the parameters of public participation. I recommend it does so through a statutory enabling framework. Such legislation should provide precision and clarity on the various processes involved and address issues like mode, extent, stages, proof of public participation, funding, responsibilities of who does what and when. Does the IEBC have the requisite quorum to conduct business? It is my finding that it does. And I'm sorry. And I have then come to the two conflicting decisions in the High Court, which were raised by parties. It is my considered view that even though horizontal stare decisis is not binding on courts of equal jurisdiction, the trial courts need to follow the decision of other judges of the same court unless there are compelling reasons to depart from the same. This is to ensure consistency, certainty, predictability, and sound judicial administration. In this context, having found that paragraph 5 of the second schedule of IEBC Act is constitutional, it is my finding that it was justified for the trial court in the Isaiah Biwott case to depart from the Katiba case. Furthermore, in this present case, I'm not persuaded that there existed compelling reasons to warrant the trial court in this case to depart from the Isaiah Biwott case. I have then laid out my reasoning around retrospective unconstitutionality and prospective unconstitutionality, and I think that I will leave that for parties to read when they read my full judgment. Finally, on the last issue, I do agree that the issue is not ripe, like the Chief Justice has stated. However, once again, the fitness and hardship test, which I developed when I was writing issue number 2, I think does apply, and I have made findings that there can only be one question at referendum, and that the provisions of Section 49 are unconstitutional. They are unconstitutional. Thank you very much.
Thank you very much, the Honorable Justice Joaquin Dongo, for rendering your opinion. It is now my pleasure to invite the Honorable Mr. Justice Wanjara to deliver his opinion.
Thank you, Chief Justice and President of this court. Mine is a summarized delivery of my judgment, because I know that, I expect counsel to read the judgment. But even if you don't read, I know that out there are Kenyans who will read it and contribute to the growth of jurisprudence in our country. And so I begin by also acknowledging the fact that I have perused the lead judgment by the President of the court, and I'm in agreement with how the contents of the background have been captured and the submissions by the parties have been paraphrased. And so this enables me to immediately go into the consideration of the 7 issues that we formulated for ourselves with your concurrence. But before I do that, I must also pay my gratitude to our colleagues at the High Court and the Court of Appeal for their gallantry and industry which they invested in this enterprise. It's due to those efforts that at this stage I can say we now find ourselves in the fog of the season's end, for those of you who read beyond the legal text. And now to the first question, whether the basic structure doctrine is applicable in Kenya, and if so, to what extent. And I begin by acknowledging the fact that never since the promulgation of the Constitution of 2010 have our courts been confronted by so polemical, elastic, and indeterminate notion as the so-called basic structure doctrine. And it all began with when a group of distinguished citizens, aggrieved by what they perceived was an imminent overthrow of the Constitution, approached the court, the High Court in particular, seeking its intervention to stop that overthrow. And I've also, like my colleagues, traced the origin of now what is being called the basic structure doctrine. And I don't think I need to go into the stages, the historical stages of how this notion, in my view, sprouted and continues sprouting in parts of the world. I think that my colleagues who have spoken have done a sterling job, and I do not intend to retrace the history of this doctrine. But I do ask, how did we find ourselves enmeshed in this kind of theorizing? Because right from the High Court and now up to this court, what we appear to be doing when addressing this notion of the basic structure of the Constitution is really a preserve of legal and social science scholars. It is hardly an occupation of a court of law, not to mention an apex court of law like this one. So how did we find ourselves in this process? It's because there can be no doubt that in approaching the court, the petitioners had been aggrieved by what they perceived as an imminent threat to the Constitution posed by this amendment bill. But instead, what they should have done, in my view, they would have laid down a prayer in which the alleged the fear of violation of the Constitution, and in support thereof, they were at liberty to deploy any arguments, propositions, and analytic tools to convince the court that indeed such a declaration was warranted. But instead, what we have here is a fundamental departure from a long-established tradition of invoking the jurisdiction of the High Court. The petitioners instead presented the court with a theoretical construct, a fait accompli, whose declaratory validation they sought. And unfortunately, the High Court elevated this proposition as designed by the petitioners into an issue for determination, even at a preliminary level. And later they would be joined by our colleagues at the High Court. But be that as it may, now that the applicability of the basic structure doctrine in courts has snowballed into a ubiquitous inquiry, we at the Supreme Court may not, without stirring justified indignation, disregard it altogether. And so, I have been compelled, just as my colleagues have been, to go into an exegesis of what then is the anatomy of this basic structure doctrine. I have asked myself whether indeed it is a doctrine, juristically speaking. I have come to the conclusion, after not just a soul searching, but serious thoughts, that what we are faced with as a basic structure doctrine is no such doctrine. Instead, it is what I consider as a school of thought, or at best, a heuristic device, which a court of law, when faced with the question as to whether a proposed constitutional amendment is of such a nature as to destroy, destabilize, or distort the constitutive authority of the Constitution, a court of law faced with such kind of question can deploy this heuristic device in its effort to answer the question. But I find no fault with this rich and diverse array of opinions, so eruditely crafted by some of our finest in the judicial system, the legal profession, academic institutions, and from far afield by way of amici curiae. And indeed, we who are called upon to adjudicate upon the affairs of men and women in their relations with one another and between them and the state are all the more privileged when served from such a tantalizing menu of ideas by the bar and the bench. Yet my discomfiture, ladies and gentlemen, with the manner in which this issue was brought before the High Court in the first instance still persists. And it bears repeating that in the ordinary scheme of things, a petitioner ought to approach the courts seeking relief on the basis of a real or perceived violation of the Constitution. But to begin by seeking a declaration that there exists somewhere in our psyche, beyond and above the Constitution, a doctrine that is nonetheless applicable in our legal system and which we have to take cognizance of even as we embark upon the determination of whether certain actions or omissions have violated the Constitution, is to lead judges onto a terrain hitherto uncharted. It is my firm view that this prolonged debate has been agonizingly stripped of the discipline of judicial inquiry, first through what I consider to be the conceptual profligacy of elevating a notion to a legal doctrine and embellishing it with an extra-constitutional force of law, and then quite inexplicably attempting to locate the minted doctrine into the text of our Constitution. So on the one hand, we are treated to what I can call lyrics of contextualism, while on the other we are strung with thirds of textualism. And so the orchestra, in my view, goes on, which, if not choreographed, could unleash an interpretative odyssey, or maelstrom, if you like, attempts to wriggle therefrom by those to come after us, which could end up in theatrical ignominy. All this while, scant attention has been paid to what I consider a majestic directive principle in our Constitution, a tool of analysis that, faced with such questions as the ones I have posed, a court of law must deploy. And I make reference to Article 259 of the Constitution, the marginal note of which reads, construing the Constitution, or construing this Constitution. And instructively, this provision is preceded by another, which I consider as a defensive armor gifted to our vigilantes of democracy and the rule of law. And this is Article 258(1). And so I go on and on, that by the end of the day, in answer to the issue as so formulated, I arrive at a conclusion to the effect that the so-called basic structure doctrine is not applicable in Kenya. I go on to consider the extent if it is so applicable, but having arrived at that conclusion, I then limit myself to some of the statements and pronouncements that were made by the two superior courts, that is to say, the High Court and Court of Appeal. In this process, I arrived at a conclusion that contrary to what was decided in error, if you ask me, there is no provision in our Constitution that is unamendable. The question for us to ask is whether the Constitution of 2010 has within it comprehensive provisions, directive principles, and normative prescriptions which are capable of withstanding any efforts from whichever quarter of abrogating it, distorting it, or fundamentally changing its equilibrium. That is the question that we should ask. And when I asked that question, I arrived at an answer in the affirmative. So that leads me to the next issue, whether the President can initiate changes or amendments to the Constitution, and whether the constitutional amendment can only be initiated by Parliament through the parliamentary initiative. In agreement with my colleagues at the High Court and Court of Appeal, I am of a firm opinion, having read the relevant provisions regarding that issue, and in context, I am of the opinion that the President cannot initiate what is referred to as a popular initiative under Article 255 and Article 257 of the Constitution, because those articles talk about an initiative to amend the Constitution by the people. And the word people here is not an ornamental one. It is a serious expression of what forms what we consider a social contract. And both the High Court and Court of Appeal held that such an initiative is reserved for what they call the common mwananchi. But before answering this question, I had to ask myself as to what really constitutes a popular initiative. In my view, a proposal to amend the Constitution through a popular initiative comes into being when there is a felt need for such an amendment by the people. But care must be, however, taken, as advised by Professor Migai Akech in his amicus brief, not to anjikunize, no, but that's my expression, not to anjikunize every stage of constitution making or amendment. In his comprehensive analysis of the history of the constitution making in Kenya, the good professor, rightly in my opinion, decries the tendency to underestimate the role played by what he calls the political elite in the making of the Constitution of 2010. And why do I agree with him? Because, in my view, a democratic polity such as ours comprises of a complex mix of the ordinary, the elite, and the philosopher, each of whom is entitled to meaningfully participate in the popular initiative of constitutional amendment. Therefore, this felt need to amend the Constitution may find expression in various fora, such as our institutions of higher learning, public symposia organized by civil society, religious and community-based organizations. If you remember the Ufungamano caucuses, and even public rallies, as long as those rallies are not organized under the influence of the political class, especially the elected one. These symposia and caucuses and rallies would have as their main objective the need to firstly clarify the rationale and content of the proposal for amendment, and secondly, to sensitize the general public and harness their support for such a proposal. At the end of the day, this felt need will have undergone such repetition, such notoriety, such refinement, and would have acquired such stability and coherence as to be capable of being formulated into a general suggestion or bill as stipulated in Article 2572 of the Constitution. At no stage is very clear to me is the role of the president, co-president, contemplated by the provisions of that article. It cannot have been lost on a casual observer of our painful history that it was the imperial presidency that mutilated the independence constitution through unchecked amendments to such an extent that at the end of the day, this country had lost any pretensions to democracy, rule of law, human rights, or social justice. And by the early 1990s, the Kenyan people were terrified, tormented, and dehumanized a lot, deprived of any sense of self-actualization in the manner in which they were governed. It was from such despondency that the people would rise to demand a new social contract, a new order that would not only restore their dignity, but also prevent the executive arm of government, if you like, read the president, and to a certain extent the legislature, from reversing the new equilibrium, from taking them from the paradigm shift to which they had cutted themselves. And so to this question, I have no hesitation in holding that the president cannot initiate a popular initiative. That takes me quite quickly as to whether indeed the president did initiate this popular initiative. It's on record, Vide Gazette notice number 514 dated 24th May 2018, that the president appointed a task force named Building Bridges to a United Kenya Task Force, or the BBI task force, if you like. This task force was composed of eminent Kenyans whose mandate it was to address the 9 key challenges facing the country. And these challenges have been identified in a memo of understanding signed between the president and Right Honorable Raila Odinga. Thereafter, the president, Vide Gazette notice number 264, published on 10th January 2020, appointed a steering committee on the implementation of the Building Bridges to United Kenya Task Force report. One of the terms of reference of that steering committee was to propose administrative, policy, statutory, and constitutional changes that may be necessary for the implementation of the recommendations contained in the task force report. It is out of which this steering committee that we now have the Constitution of Kenya Amendment Bill of 2020. I, on my part, find, although the High Court later described the task force as an unconstitutional outfit, I, on my part, find that there was nothing unconstitutional in the appointment or composition of either the task force or the steering committee by the president. What remains is whether the president can be regarded as having initiated the process that culminated into the bill that we now have. And in conclusion, I have stated that taking everything into consideration, all the stages, all the processes that led to the bill, I find it difficult to distance the president from the involvement and the initiation of the popular initiative. Therefore, I find that the President did actually originate this initiative. The conclusion deriving from this I shall return to in my final conclusions. And now, next is whether the second schedule to the Constitution Amendment Bill 2020 is unconstitutional. Both the High Court and Court of Appeal found that schedule unconstitutional. I have considered the reasoning by the two superior courts. I have looked at the relevant law, and I come to a similar conclusion that this second schedule to the Constitution of Kenya Amendment Bill 2020 is actually unconstitutional. Fourth, I consider whether civil proceedings can be instituted against the President in person or a person performing the functions of the office of the President during his tenure of office. And I know I have taken into cognizance the submissions by the Attorney General urging the court to find that such proceedings cannot be instituted against the President or a person performing the functions of that office. I also know that there are those who have strenuously opposed the Attorney General's submissions and have argued that such immunity is limited, so limited that the President can on occasion be sued where or if he violates the Constitution, and if he violates any other law when he is not acting in his capacity as the President. And I have, having carefully considered those arguments, I find considerable difficulty in appreciating the rationale or basis upon which first the High Court found that notwithstanding the clear and unambiguous language in Article 1432 of the Constitution, that the President can still be sued in his personal capacity for acts or omissions alleged to be in violation of the Constitution. Why did the High Court introduce the phrase "only protected"? And then turning to the finding by the Court of Appeal, I find similar difficulty, because it is clear that should the President engage in an act or omission that is violative of the Constitution, there are constitutionally recognized pathways through which such violation can be put right. And I have mentioned and discussed them in the body of my judgment. But a more profound legal reason for presidential immunity in both his private and official capacity is to be found in Article 1433 of the Constitution, which provides that where provision is made in law limiting the time within which proceedings under Clause 1 or 2 may be brought against a person, a period of time during which the person holds or performs the functions of the President shall not be taken into account in calculating the period of time prescribed by that law. And what is this law referring to? It must be referring to the law of limitations. And then why would the President be denied the benefit of limitation of actions? Precisely because the President cannot be sued in his private capacity during the tenure of his or her office. And I also state that once a president, always a president until he or she vacates the office, because you cannot be a president today and tomorrow you are not a president, so that you may be so sued. That brings me to issue number 5, the place of public participation under Article 10 vis-a-vis the role of IEBC and whether there was public participation. And in response to this, after serious analysis, I find that there was no obligation on the part of the IEBC at the time it embarked upon the verification of signatures to satisfy itself as to whether there had been public participation before the bill and signatures were transmitted to it. I do not find anything in the Constitution that obliges the IEBC to carry out that function. But what about the promoters of the popular initiatives? What about Dennis Waweru, Mr. Waweru, Honorable, and Honorable Junet, who have defined themselves as promoters? Were they not supposed to undertake meaningful public participation? The argument that I see here against such a proposal is that the process of popular initiative begins with the collection of signatures. And I do not agree with that proposition, because before you collect signatures, there must be something you are offering the people. You are taking to the people either that general suggestion or a draft bill. And if you are seeking their signatures, surely the people must understand the contents of the bill to which they are appending their signatures. I have read the contents of the affidavit sworn by Honorable Waweru, the contents of which state that there was a comprehensive and robust process of consultation. But the contents of that robust consultation are not clearly stated. And so I'm concluding that when it comes to the promoters of the popular initiative, I do not myself think that they undertook sufficient or meaningful public participation under, within the meaning of Article 10 of the Constitution of 2010. And now this brings me to the interpretation of Articles 88 and 250 of the Constitution with respect to the composition and quorum of the IEBC. This one has been thrust to us because somewhere along the line, the petitioners did allege that at the time it undertook the verification of signatures, the IEBC lacked the requisite quorum to be able to constitutionally undertake that task. And then I have also looked at the history of the legislative form that prescribes the quorum of IEBC. I've looked at the contents of Article 251 of the Constitution, and I come to this conclusion, that if, as indeed we must conclude, that at the time the IEBC undertook the verification of signatures, it was constitutionally and properly so constituted, how on earth can we then say that it lacked quorum to undertake the tasks for which it was properly constituted? And then my attention has been drawn to the contents of paragraph 5 of Schedule 12, I think, to the IEBC Act, which sets that quorum at 5. And I'm simply saying that as between a constitutional provision, you cannot use the provisions of a statute to override the majesty of a constitutional provision. And having so said, I find that the IEBC had the requisite quorum to conduct the verification of signatures and any other task that the Constitution requires it to undertake. And finally, I come to this vexed question of whether the interpretation of 25710 of the Constitution entails that all, or requires, that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions. I had no difficulty in disposing of this particular issue because it was not ripe, as rightly observed by my colleague Tuyot J.A. of the Supreme Court. And I'm not the kind of person to engage in abstract exercises. Because if we did that, then we would be also encouraging Kenyans, as indeed they have done to us in this basic structure imbroglio, to come with abstract questions and expect us to expend valuable judicial time disentangling the same. So what are my conclusions? One, the basic structure doctrine is not applicable in Kenya in the way and manner in which it has been formulated, because it's no such doctrine, neither does it have a force of law juridically so understood. I've said it is a heuristic device. The four sequential steps of civic education, public participation, and the rest are not also applicable to the process of constitutional amendment envisaged under Articles 255, 256, and 257. Such steps, and not necessarily in that order, would become operative in the event of a seismic constitutional moment which dictates that the people must exercise their primary constituent power to make a new constitution or re-establish the constitutional order. And three, the president cannot initiate or activate any constitutional changes through a popular initiative process as envisaged under Articles 255 and 257 of the Constitution. For the president actually did initiate the proposed constitutional amendments, and the effect of that, I believe, should be able to come out in the final disposition of this dispute by this court. The second schedule to the Constitution of Kenya, Amendment Bill 2020, is unconstitutional. Civil proceedings cannot be brought or instituted in any court of law against the president or a person performing the functions of that office in their personal capacity during their tenure of office in respect of anything done or not done in the exercise of their powers under the Constitution. And seven, the IEBC is not under any obligation to ensure that the promoters of a popular initiative have facilitated public participation before transmitting the resultant bill to it. But I also say that in this particular instance, no meaningful public participation was conducted by the promoters of this bill. 9, the IEBC had the requisite quorum at the time it undertook and completed the verification of signatures. And finally, the interpretation of Article 257(10) in the manner in which the issue has been formulated is not ripe for consideration, not just by this court, by any other court in this country. Before I sign off, my mind races back to those 3 days in this tent during which I and my colleagues here sat patiently, pensively, and attentively, listening to the impassioned pleas from the bar so commandingly assembled. Not that this was the first time I was finding myself having to endure the perorations of counsel, some of them experienced jurists and others not so senior. But it was such a moment when the basics of a basic structure were basically spewed unto us with such aplomb hitherto unseen, save during the hearing of a presidential election petition. What we were told, however, I also remember that it was on such occasion that we were reminded that our colleagues at the High Court and Court of Appeal, the colleagues at the High Court had built a foundation, and those ones at the Court of Appeal had constructed a wall upon it, and that now it was our turn to paint that wall. But we were not told with which colors we were to undertake this alluring task. I also remember being urged to row roar like lions in the wild as we asserted the supremacy of the Constitution. But who could fault counsel for invoking our hallowed symbol of nationhood? Yet at that moment I could not help but cringe, for the sound of a roar of a lion in the wild stirred in me images of the terrifying language so beloved by our politicians, the language of tsunamis, of earthquakes, volcanoes, war and thunder. And that is why I cringed. And then I remembered that not so long ago, this court had in one of its judgments, and really in true oracular rendition, or so I thought, decreed as follows. But it does appear, as my colleague Judge Lenaola here apprehended, counsel do not read the judgments of this court. And now I am forced to read this decree to you, so that even if you don't reread it, it shall be acted in your mind. And this is what this court said at that time. What of the argument that this court should not subvert the will of the people? This court is one of those to whom that sovereign power has been delegated under Article 13C of the same Constitution. All its powers, including that of invalidating the presidential election, is not self-given nor forcefully taken, but is donated by the people of Kenya. To dishonestly exercise that delegated power and to close our eyes to constitutional violations would be a dereliction of duty, and we refuse to accept the invitation to do so, however popular that invitation may seem. Therefore, however burdensome, let the majesty of the Constitution reverberate across the lengths and breadths of our motherland. Let it bubble from our rivers. To read this decree to you, let it boomerang from our hills and of our motherland. Let it bubble from our rivers. To read this decree to you, let it boomerang from our institutional learning of our motherland. Let it toll from our bubble from our rivers. To read this decree to you, let it boomerang from our institutional learning of our motherland. Let it toll from our bubble from our rivers. To read this decree to you, let it boomerang from our institutional learning of our motherland. Let it toll from our bubble from our rivers. To read this decree to you, let it boomerang from our institutional learning of our motherland. Let it toll from our bubble from our rivers. To read this decree to you, let it boomerang from our institutional learning of our motherland. Let it toll from our bubble from our rivers. To read this decree to you, let it boomerang from our institutional learning of our motherland. Let it toll from our bubble from our rivers. To read this decree to you, let it boomerang from our institutional learning of our motherland. Let it toll from our bubble from our rivers. To read this decree to you, let it boomerang from our institutional learning of our motherland. Let it toll from our bubble from our rivers. To read this decree to you, let it boomerang from our institutional learning of our motherland. Let it toll from our bubble from our rivers. To read this decree to you, let it boomerang from our institutional learning of our motherland. Let it toll from our bubble from our rivers. To read this decree to you, let it boomerang from our institutional learning of our motherland. Let it toll from our bubble from our rivers. To read this decree to you, let it boomerang from our institutional learning of our motherland. Let it toll from our bubble from our rivers. To read this decree to you, let it boomerang from our institutional learning of our motherland. Let it toll from our bubble from our rivers. To read this decree to you, let it boomerang from our institutional learning of our motherland. Let it toll from our bubble from our rivers. To read this decree to you, let it boomerang from our institutional learning of our motherland. Let it toll from our bubble from our rivers. To read this decree to you, let it boomerang from our institutional learning of our motherland. Let it toll from our bubble from our rivers. To read this decree to you, let it boomerang from our institutional learning of our motherland. Let it toll from our bubble from our rivers. To read this decree to you, let it boomerang from our institutional learning of our motherland. Let it toll from our bubble from our rivers. To read this decree to you, let it boomerang from our institutional
application of a doctrine or legal principle, the same must have universal application. I say this because not all legal doctrines and principles are universally applicable due to the differences in legal systems, such as the civil and common law. This is also because of our unique peculiarities, such as states due to our historical, cultural, and social systems. My thoughts on this are further fortified by our Constitution, read together with the Judicature Act, Cap 6, laws of Kenya, which allow us to apply the doctrine that are in line with our laws, more so if they assist us better to interpret and apply them. So there's a lot of reading material which I've referred to. So directly is the doctrine. Is the doctrine of basic structure applicable to Kenya? The basic structure doctrine is not only new to our, is not entirely new to our jurisdiction. Much like the other countries, Kenya has had opportunity to grapple with the doctrine of basic structure in our circumstances. During our journey of constitutional making, we had the CKRC appointed in November 2000. The commission chaired by Professor Yash Palgai convened the National Constitutional Conference for discussion, debate, amendment, and adoption of its report and draft bill, famously dubbed the Bomas Conference, due to taking place, which was taking place at the Bomas. The Bomas Conference was convened and adjourned 3 times, out of which a draft was amended and adopted by the acclamation by the conference, sitting in plenary on 23rd March 2003, then handed over the Constitution to the Kenya Review Commission. However, before the conference was adjourned, there was a number of challenges to the validity or legitimacy of the entire constitutional review process and its outcome. One of which was the case that I've referred to, Timothy Njoya and others versus CKRC. The applicants sought inter alia, that was 2004. The applicants sought inter alia a declaration that certain provisions of the Constitutional Review Act transferred, diluted, and vitiated the constitutional power of the people of Kenya to adopt a new constitution. The court held that the new constitution needed to be ratified through a national referendum, as the right to a referendum was a fundamental right of the people in exercise of their constitutional power. Ringera J., who is now retired, who was in the majority, concurred with the pronouncements of Kesavananda that Parliament did not have the power to alter the basic structure of our constitution. And there's a citation here, which I don't have to go through, where Justice Ringera, and which means our courts, recognize the principle of, this is my submission, principle of basic structure. Application of the doctrine again arose in the case I referred to, Patrick Ouma Onyango. One of the issues that arose was whether Parliament, in its limited delegated role, had the power to debate, alter, or amend the Bomas draft constitution, which was the product of the view of the people. It was also questioned whether that interference by Parliament had the effect of elevating the members of National Assembly above the people of Kenya as sovereigns. The court, consisting of Nyamo, Wendo, and Mkule, held, and I think I should refer to it very quickly. We further find and declare that what will give purity to the process is the enactment of the proposals as a constitution by the people in the referendum. It is the enactment by the people which gives purity and validity. Yes, they are the touchstone of validity, the people. The applicants in their final written submissions did concede that constitutional power cannot be restrained. We exercise judicial power on behalf of the people, and we cannot restrain for them in making their choice. These are 3 judges of our courts speaking for the people of Kenya. We find and declare that the basic steps in constitution making are 1, popular consultations, 2, framing of the proposals, 3, referendums or Constitutional Assembly elected and mandated. We find the challenge process has satisfied all the 3 steps. We find and declare that the process is not flawed. In our view, the real judges of the process are the people of Kenya in view of the past involvement with the process as outlined. I'm not going to go through all that. There's a lot of material which I will let you read when you get this, this judgment. Basically, it is to show that Kenya itself, due to the constitution-making process that led to 2010, people discussed in depth the history and the problems that Kenya went through, the hyper amendments that we had gone through, and the result was the 2010 Constitution, and in particular, Chapter 16 and Articles 255, 256, 257, which I will be persuading you in this opinion that contains the basic structure that supposed to protect the people from amendments by even the delegated power, which is Parliament. After the promulgation of the Constitution in August 2010, there was a case of the Commission for the Implementation of the Constitution versus National Assembly of Kenya, where the National Assembly, by the Constitutional Amendment Bill 2013, sought to amend Article 260 of the Constitution in respect of the definition of state office. I'd already discussed that. Then there was the case of Priscilla Kivuitu. Then we have various cases. Attorney General versus Randu Nzai, whereby the court held that in view of the foregoing, the appellant's contention that the respondent's agenda of succession is unconstitutional has no basis in law. The respondents have a constitutional right to demand succession, but that can only be done within the confines of the Constitution as stipulated under Articles 255, 256, and 257 of the Constitution. Now, in all these cases, the applicability of the basic structure doctrine was not a substantive question of the courts. The courts were asked to determine, unlike the present one. So in this case, through my proposals here, which I don't wish to go through, and I have told you the art of brevity is not donated to everybody, and I'm not one of them. So I'll let you read. But I'd refer to what I've said here. That there was this decision by Justice Mativo in the Third Alliance case, Kenya versus another versus Head of Public Service, Joseph Kinyua, and others versus Martin Kimani and others. In that case, Mativo, Justice Mativo, said, he referred to this doctrine and he stated as follows: the command in Article 259 is instrumental in shaping the constitutional jurisprudence in this country. Call it by any name, basic structure, or whatever, but Article 259 provides the manner in which the Constitution is to be interpreted to maintain its fabric, which cannot be dismantled by any authority created by Constitution itself, be it the Parliament, the Executive, or the Judiciary. Couched in this doctrine are a few crucial aspects. First, that constitutions are considered to be the act of the people as the almighty sovereign. We see this as the power of the people recognized and documented in the preamble of our Constitution, which begins as follows, and I quote, "We, the people of Kenya, exercising our sovereign and inalienable right to determine form of government of our country and having participated fully in the making of the Constitution. So I've gone through this and I invited you, as some of my colleagues have said, some of our judgments are long. Mine is 125, and I would not wish to read through it. I invite you to read carefully, but after going through all my arguments and citing various cases and showing the historical road we passed to acquire, to get this very important Constitution 2010, of which I'm sure all of us are proud of and all of us cherish, I came to the conclusion, my disposition on this issue, first issue, noting our history, context, and constitutional text, I find that the doctrine of basic structure is applicable to Kenya. Further, that the basic structure of a constitution can only be altered or denatured through the primary constituent power. C, it's my further finding that the primary constitutional power is the unbound power of the people to make or unmake constitution, and genuine exercise of the same can be identified by the 4 sequential steps of civic education, public participation, constituent assembly, plus referendum. So I've set out in the judgment what the basic structure entails. And I've set out and I've discussed the issue, where, can the basic structure of the Constitution only be altered through primary constitutional power, and what constitutes the primary power? I've discussed that, and that was my dispensation. So that is my dispensation in that question, and I invite you to read that. So in the interest of brevity of time, I'll go to another issue. Issue number 2. Issue number 2, whether the President can initiate changes, amendments to the Constitution, and whether constitutional amendment can only be initiated by Parliament through a parliamentary initiative under the Article 256 of the Constitution, or through a popular initiative under the Article 257 of the Constitution. I'll give a summarized view of this, which is contained in this opinion and judgment, and also one more issue. The other issue is the place of public, issue number 5, the place of public participation under Article 10 vis-a-vis the role of IEBC. The other 3, I wish just to set out and read and state my disposition without going into the details, and I leave that to you to read when you have the time. Regarding question 2, Gatembu J.A. rightly observes that Article 257 makes no qualification of who may or may not promote a popular initiative, and there is no explicit bar against any person, including the President, from promoting a constitution amendment by popular initiative. It is therefore upon the court to interpret and determine the parameters of the same. Now, Justice Tuyot gave the historical context of highlighting the genesis of popular initiative, the clauses in the Constitution. This can be traced back to the CKRC final report, where the Commission noted that although the conference agreed the process of constitutional amendment, this must not be left entirely to Parliament. Different options needed further thought, particularly with regard to the exact modalities of engaging the constituent power of the people. The Commission, in addressing the issue, recommended that citizen and the civil society may initiate constitutional amendments through a process called popular initiative. This was then captured in the zero draft at Article 346, and the same was retained in the Boma's draft as follows, and I quote, an amendment to this constitution may be proposed by a popular initiative signed by at least 1 million citizens to vote. So the genesis of the issue of popular initiative was way back during the CKRC conferences. The same survived the Naivasha Accord of November 2004 and the Kilifi Accord of June 2005. And also, it was retained in the harmonized draft. The objective for the popular initiative, as captured by the final report of the Technical Working Group of Group K of the Constitution of Kenya Review Commission on Constitutional Commission and Amendments to the Constitution held up to the creation of 2010 Constitution, the report said a committee introduced a novel idea called popular initiative. This is an innovative where the citizen can only by their own motion initiate amendment to the Constitution by way of a popular initiative, either in the form of a general suggestion or a formulated draft bill. The committee explained that their intention was a starting point towards curbing dictatorship by Parliament. 2-year JA went to hold that, contrary to the AG's submission that the intention of the popular initiative was to curb parliamentary monopoly for both people and state organs, the historical perspective demonstrated that the popular initiative was a preserve of the citizens. It's for this reason that I concur with Kiage J when he concluded that the popular initiative route must be citizen-conceived, citizen-initiated, and citizen-driven process, and the citizens are the ordinary people, whether as individuals or as organized civil groups. Regarding the assertion that the president can initiate process of constitutional amendment by way of popular initiative in his capacity as a private citizen, two pertinent issues arise. First is the fact that Article 257.5 subscribes the president a role in the amendment process. Article 257.5 provides that if a bill to amend the Constitution proposes an amendment relating to matters under Article 255, the President shall, before assenting to the bill, request IEBC to conduct a national referendum within 90 days. The import of this provision is it assigns the President the power to decide whether or not to hold a referendum. To ensure the integrity of the process of constitutional amendment pursuant to Article 257, we cannot have the President playing the role of umpire, who is expected to be neutral and act in the interest of the nation, in a process where he is also a player advocating for his own personal interests and agendas. Clearly, there would be a serious conflict of interest. This would be detrimental to the interests of the people and the nation. Second is that the President ceases to be an ordinary citizen the minute he takes office. Article 131 describes him as the head of state and government, who exercises executive authority of the Republic. He is also the Commander-in-Chief of the Defense Kenya Forces. He chairs the National Security Council pursuant to Article 240, which exercises supervisory control over national security organs, including the Kenya Defense Forces, the National Intelligence Service, and the National Police Service. He is also the symbol of national unity. He plays the various powerful roles pursuant to Article 132, including appointing cabinet secretaries, attorney general, principal secretaries, high commissioners, ambassadors, as well as diplomatic and consular representatives. He is empowered by virtue of Articles 132, 4D and E to declare a state of emergency or declare war, respectively. He may also, pursuant to Article 192, even suspend county governments, either in emergency arising out of internal conflict or war, for any other exceptional circumstances. By virtue of holding this office, the President is accorded immunity with Article 143. So you can see the special position of the President. And we are saying, and I'm saying that the President cannot act as a promoter or initiator, even if you have to use that name, initiator, he cannot commence or get involved. In this particular case, there is evidence that not only did he start the process, but he was also involved throughout, and all steps taken by others the genesis was his own actions through the Gazette notice and the legal steps that he took. This power and control that the president exercises by virtue of his position was evident in the inception of the amendment bill, as rightly pointed out by the learned judges of the superior courts. Right from the handshake that was between him as the elected president following the contentious 2017 general elections and rerun, and his competitor and challenger, Honorable Raila Odinga. He then proceeded to appoint that. So I gave, in this narration, I give the history of all the steps and that he was involved in directly, in the building bridges to a united Kenya, from a nation of blood ties to a nation of ideals, the appointment of the teams, the Gazette notices throughout. The first step had a domino effect, and throughout he was involved, and the government's role was also very clear. The difference in the amendment bill that was launched on 25th November 2020 from the amendment bill contained in the BBI Steering Committee report presented to the President on 26, 2020 are better contextualized in discussing the place of public participation under issue number 5. Now, so my conclusion there is that on whether the President can initiate a popular initiative to amend the Constitution under Article 257, it is my finding that he cannot. Issue number 3, on whether the second schedule to the Constitution of Kenya, Amendment Bill 2020, was unconstitutional, I find that on issue number 3, I find that the second schedule of the Constitution of Kenya Amendment Bill to have been unconstitutional. On question number 4, it is my finding that pursuant to Article 143.2, no civil proceedings can be instituted against the President or person performing the functions of the office of the President during their tenure of office with regard to anything done or not done contrary to the Constitution. And regarding public participation, I wanted to say more, but I will wish to save time, and I will invite you to read the judgment. On issue number 5, I find that by the time the process was stopped by the High Court, the public participation undertaken was not sufficient, reasonable, or meaningful. Issue number 6, I find that the IEBC was not properly composed or quoried while it undertook the verification of signatures pursuant to Article 257(4) of the Constitution. However, in the light of the decision in Isaac Biot case, IEBC's undertakings in compliance with the decision were lawful. Number 7, it is my finding that the interpretation of Article 257(10) on whether the proposed amendments should be submitted to the people as separate but distinct referendum questions, this issue was not ripe for determination On the issue of costs, I recommend that, being a public interest matter, the parties ought to bear their own costs of proceedings in the High Court, Court of Appeal, and in the present appeals. The final orders of this court are as will be contained in the lead judgment of the Chief Justice and the President of the Court, and which he will advise the court before we end these proceedings. I've had to do this, but I invite you please carefully read my whole judgment. Thank you.
Thank you very much, the Honorable Mr. Justice Ibrahim Mohammed. Allow me now to invite the Honorable Justice Mwiru, the Vice President of the Court, to render her opinion.
Thank you very much, Judge President. The modus operandi today from the side of the court was to deliver summarized versions of the judgment. The 150 plus pages will be at your disposal at your time that the President of the court shall advise. The lead judgment carries all the background to the case quite comprehensively, the history of these proceedings, the fact submissions of all the parties, and the prayers sought. I see no need to rehash that. But at a personal level, I shall read what I consider to be brief. The rest, those who are interested in reading judgments afterwards, shall read. To me, democracy is a perpetually contested condition. Within it, through discourse, persuasion, contention, and reconciliation, we are constantly in mutability towards improving our condition through perfecting the substance of the norms and agreements by which we agree to coexist and flourish. Whilst we see this across our courts every day, there are certain matters that attenuate our constant pursuit of socio-political perfection. The petition before this court is one such. Within the context of our national journey towards perfecting our constitutional democracy, the important role of this court and all parties to this petition becomes all the more apparent. The crux of this petition, as I said, is the extent and nature of constitutional amendment in Kenya, especially within our nation's history of constitutional development, and more specifically, the experiences and processes that birthed the Constitution of Kenya 2010, any initiative that seeks to change that body of fundamental principles according to which we as Kenyans have agreed to be governed, our Constitution deserves the most attention of all Kenyans, whose duty under Article 3 is to respect, to uphold, and defend the Constitution, and all state organs who under Article 2 exercise their delegated authority only through and in accordance with that Constitution. The history of constitutional development in Kenya has been laid out concisely and in detail, both in the High Court and the Court of Appeal, and even in our decisions. This history is most relevant in my view. This court, the Supreme Court, has on numerous occasions asserted the importance of historical context as a key tool for courts and tribunals in the interpretation of the provisions of our transformative charter. Though a significant factor, it is not and ought not be the only lens through or the weightiest factor upon which we consider the questions of constitutional interpretation. Professor Richard Albert referred to in both the judgments of the superior courts below, speaks of the, quote, rise of unamendability, unquote, and the quality of formal amendment rules in terms of their availability for both good and ill, as posing a challenge for constitutionalism in that though rules of change are indispensable for the functioning of constitutional democracy, they at once, quote, open the door to the demise of constitutional democracy itself, unquote. Therefore, me poses the question, how then, quote, can we protect constitutional democracy from the misuse of its own devices, unquote? The late Professor H.W. Okoth-Ogendo illuminates this discussion by pointing out that it is pointless having a constitution if constitutionalism is not our concern. I am most cognizant of our history as a country, as well as the history of the development of our much cherished 2010 Constitution. I'm also aware of the principles developed by this court regarding historical context in the interpretation of the Constitution, a living document that speaks from the past through the present to the future. I must, however, state that the role of our courts must remain within the architecture of the Constitution. It is bound by it. All courts are bound by it. The exercise of discretion must be judicious. Though it is the court's task to breathe life into the Constitution and to ensure that its text is constantly speaking to the transformative and emancipatory ideals therein, on the other hand, the text of the Constitution cannot be seen as devoid of meaning and content, merely to be filled by ideas and opinions by those on the bench, no matter how laudable and noble and well-intentioned those may be. A balance must be maintained, and such balance is crucial to the very architecture of our constitutional democracy, for the courts too must not see themselves as immune to being inimical, despotic tendencies. This is especially true in regard to constitutional amendment and the exercise of sovereignty as acknowledged in the Constitution directly and indirectly through processes that are prescribed in our Constitution. The courts must seek to steadfastly and purposely defend and protect the Constitution and constitutional processes through which the people of Kenya express their sovereign power, not on the basis of justifiable apprehension, and no matter the nobility of the cause, employ judicial craft to retain certain moral or doctrinal limits into the exercise of such sovereign power. It is the sovereign, the people who must decide, and responsibility of all state organs only exercise state authority as delegated by the sovereign. That is to remove all extra constitutional impediments to the free exercise of such sovereign power. This Constitution has been stretched in its over 10 years existence, and perhaps this is the most serious attempt yet to espouse its limits in the wake of attempted amendments. To demonstrate the magnitude of this case before these courts, while the High Court framed 13 issues for determination arising out of the consolidated petitions, the Court of Appeal expanded them to 21. On our part, we found 7 that required determination, And that's what we are doing this morning, this afternoon. That said, I now proceed to determine the 7 issues as framed in summary as my understanding of the Constitution and the law allows me to do. And the first issue is that doctrine and the basic structure itself. If a doctrine is a legal principle of long usage that is widely accepted as such, then my finding is that the Kesavananda case is a judicial reasoning which cannot be elevated to a doctrine above the Constitution. And therefore, the Constitution of Kenya 2010, I find, has a basic structure. But as for the basic structure doctrine, I find that the same is not derivable from our Constitution, and that structure, wherever else it may be found and applied, does not, in my view, apply in the Kenyan constitutional context. The manner and process through which sovereign power is exercised in this country is by the citizens in its different forms and is fundamentally important under our constitutional architecture, and the Constitution can be changed through other mechanisms, not limited to the primary constituent power. The second issue, the President, in my reading of Article 143, cannot, no, not 143, sorry, Article, issue number 2, the President cannot directly initiate changes or amendments to the Constitution. An amendment of the Constitution can only be initiated through a parliamentary or popular initiative under Articles 256 and 257 of the Constitution of Kenya 2010. Consequently, therefore, the Constitutional Amendment Bill 2010 is unconstitutional. On the third issue, the second schedule to the Constitutional Amendment Bill 2010, I find no difficulty in finding that that bill is unconstitutional insofar as it directs the IEBC on not only the elimination of the number of constituencies, but also the distribution of the proposed new constituencies and the timelines within which to operationalize the same within the constitutional parameters that are given in Article 87 of the 2010 Constitution. The Commission cannot be directed. Article 89 was not even sought to be amended in its entirety. The bill, therefore, is unconstitutional in my finding. On issue number 4, even before I decide whether or not the President can be sued first, it's important to note that there really was no proper service of the process, and the President was therefore not accorded an opportunity to participate in the pleadings in his personal capacity. as he had been sued in his personal capacity. And I find further that Article 143, any interpretation of that article must come to the conclusion that the president or the person performing the functions of the office of president cannot be sued during tenure. And although their immunity is not absolute immunity to impunity, it is nevertheless absolute immunity during the tenure of office. In my judgment, you will see that I have said if any proceedings were begun before assumption of office, they are stayed. That's what the Constitution says, and they are resumed or fresh ones initiated after leaving office. On public participation, issue number 5, I have said where it mattered most, I found no reasonable or any degree of public participation, which is a value in Article 10 of our Constitution that I could consider allowing the standing of the actions that were done without public participation. This court set the test in BAT versus the CS Health, and I find therefore that for me, the test was not met. On issue number 6, the totality of my finding, even considering what the findings in Isaiah B. Watt and in the Katiba case and the effect of the Katiba case on Section 5 were, I would rest with Article 250 of the Constitution and say that the IEBC was not only properly constituted with the minimum number that was required by Article 250, it had quorum, and nothing was shown to the contrary. The last issue, on the last issue as to the referendum question, I agree with all my colleagues in this court and in the courts below that have said that the matter was not ripe. It still is not. The bill never went past the IEBC for it to be submitted to referendum. I find therefore that engaging in a discussion in that matter is a complete waste of precious judicial time, and I would not get myself entangled in such a non-issue as that one. As to costs, this being a public litigation issue, I would say that they lie with each party, and those are the orders. The body of the judgment shall give my explanations for each of my findings. I thank you, Judge President.
Thank you very much, the Honorable Lady Justice Miru, Vice President, for that rendition. Before I read the final disposition of the court, allow me to express the court's appreciation to all counsel and all parties and amici appearing in this matter for your erudite and well-researched oral and written submissions. We also wish to thank you for patiently sitting and bearing with us for the last 6 hours as we delivered this judgment. The court notes in a special way the galaxy of legal luminaries, among them distinguished legal scholars, professors of constitutional law from Kenya and other jurisdictions, who joined this case to enrich our judgment. We found their views very useful, although they were varied and divergent, especially on the applicability of the basic structure and doctrine, and whether it had acquired international application under the provisions of Article 2.5 of the Constitution. The court's decision has been enriched and benefited a great deal from the arguments advanced by all the parties who appeared before us. We hope with the full noise of time, even our local scholars will find their way in other jurisdictions, in other countries, America, Germany, or even Africa, to share our rich jurisprudence with those courts. We also wish to thank our law clerks for their research and exceptional industry in supporting the work of this court. That said, in the course of writing this judgment, the court observed with concern some commentaries on the pending judgment carried out in the social media by some counsel, some of whom are appearing in this matter. The contents of those social media commentaries were, in our view, meant to influence, intimidate, or scandalize the court. This unfortunate practice is emerging, and unless it is checked, it will erode the confidence and the dignity of the courts. It would also amount to unprofessional conduct, especially by counsel appearing in this matter, and even counsel who are not in this matter, but know very well that they cannot comment on a matter that is pending judgment. It is a well-established practice that counsel and indeed parties should refrain from directly or indirectly trying to improperly influence the courts to rule in one way or the other. Once judgment has been reserved and judges retreated to consider submissions and write judgment, learned counsel Mr. Nelson Avi and Ms. Esther Angawa, who appeared for the first to the fifth respondents, took to the social media, Twitter, on different occasions. On 19th February and 15th February 2022, and they cast aspersions on the courts. For counsel to appear before the apex court, then proceed to hurl unnecessary diatribe, insults, and speculations on a pending judgment amounts to unethical conduct on the part of the counsel. The use of social media to disparage the court with the intention of lowering the dignity and the authority of the court or influencing the outcome of the case pending before the court is a trespass on the bounds of legitimate advocacy and moves to the realm of professionalism to professional misconduct. This is in line with the provisions of Section 61 of the Advocates Act that deals with dishonorable conduct incompatible with the status of an advocate. Equally culpable is the conduct of senior counsel, Mr. Ahmed Nasir Abdullahi, who, though not counsel appearing in this matter, took the lead role in disparaging and besmirching the court as evidence from his posts on Twitter on 8th February 2022, 15th February, and even as late as yesterday, the 29th March 2022. Section 17 of the Advocates Act envisages the rank and dignity of senior counsel is conferred on the basis of irreproachable professional conduct and exemplary service to the legal and public service in Kenya. These standards are expected to continue even after conferment of the rank of the senior counsel. Advocates should familiarize themselves with the code of standards of professional practice and ethical conduct, Gazette Notice number 5212, and strive to conduct themselves in a manner that preserve and strengthen the dignity, the honor, and the ethics of the profession. Consequently, advocates should refrain from conduct that amounts to indirectly attempting to influence decisions pending before courts. Relevant to the use of social media, we wish to draw the attention of advocates to the standard of professional practice and ethics conduct number 10 that spells out inappropriate conduct. This caution should always play in the mind of advocates who are tempted to utilize social media to advance their cause. I will now proceed to give the final disposition of the court. Having considered the 7 issues framed by this court for determination, the final orders are as follows. 1, the basic structure doctrine is not applicable in Kenya. Ibrahim, Supreme Court Judge, dissenting. B, in order to amend the Constitution of Kenya 2010, the 4 sequential steps as pronounced by the 2 superior courts below are not necessary. Ibrahim, Supreme Court Judge, dissenting. On the second issue, the first part A, the President cannot initiate constitutional amendments or changes through the popular initiative under Article 257 of the Constitution. Joaquin Dongo, Supreme Court Judge, dissenting. The B aspect of that, issue 2, the President initiated the amendment process in issue. Joaquin Dongo and the Naura Supreme Court judges dissenting. Consequently, C, consequently, under Article 257 of the Constitution, the Constitution Amendment Bill of 2020 is unconstitutional. Joaquin Dongo and the Naura Supreme Court judges dissenting. The third issue, the second schedule of the Constitution of Kenya Amendment Bill 2020 is unconstitutional for being in breach of Article 10.2 and 87.7a of the Constitution of Kenya 2020 for lack of public participation. Joaquin Dongo, Supreme Court Judge, concurring. 4, civil proceedings cannot be instituted in any court against the President or the person performing the functions of the office of the President during their tenure of office in respect of anything done or not done under the Constitution of Kenya 2010. That was unanimous. 5A, there was no obligation under Article 10 and 257.4 of the Constitution on IEBC to ensure that the promoters of the Constitution of Kenya Amendment Bill 2020 complied with the requirements for public participation. Unanimous. B, there was public participation with respect to the Constitution of Kenya Amendment Bill 2020. Mwiru, Vice President, Ibrahim and Wanjara Supreme Court judges dissenting. Five, IEBC had the requisite composition and quorum to undertake the verification process under Article 257.4. Ibrahim, Supreme Court Judge, dissenting. 7, the question raised regarding the interpretation of Article 257.10 of the Constitution on whether or not it requires that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions was not ripe for determination. Joaquin Dongo, Supreme Court Judge, concurring. Each party shall bear their own cost, this being a public interest matter. Consequently, the consolidated appeal is determined as follows. The appeal is allowed on issue number 1. The appeal is allowed on issue number 4. The appeal is allowed on issue number 5. The appeal is allowed on issue number 6. The appeal is allowed on issue number 7. The appeal is disallowed on issue number 2. The appeal is disallowed on issue number 3. Those are the orders of the court. Ladies and gentlemen, thank you very much for your patience. We will seek your indulgence to perfect the final judgment. As you can see, we have so many pages to put together to come up with one judgment. Putting it together, it was very difficult because of the privacy involved and the logistics to put it together before delivery. We intend to do this and issue the judgment of the court on Tuesday next week. Today, we will issue a press summary of this judgment, which will come out shortly in about 1 hour. Thank you very much for your forbearance and for your cooperation. Is your mic on?
Thank you. I was saying, Madam President, Madam Deputy President, your Ladyship, my Lords, we take this opportunity on behalf of Council to thank you most sincerely for your very detailed decision on these very difficult and fundamental issues which have the effect on the future progress of constitutionalism in this country for many years to come. I think I talk on behalf of all council when I say they are very grateful for your patience, your industry, and the detailed means and effect by which this judgment has been delivered. I also take this opportunity to apologize on behalf of Solicitor General, who was here representing the AG, but had to leave because he is before another bench. Thank you, my ladies, my lords.
Thank you very much for those kind words. The court is now adjourned. Have a very nice afternoon and God bless you.